Good morning, everybody, and welcome to the panel on fixing the interwebs and creating predictability in our online fundamental rights. We have a very interesting and very diverse range of speakers to look forward to. The issue at stake is looking at the various obligations or demands that are being placed on intermediaries to impose restrictions for public policy reasons, and questioning whether going along a long continuum, whether it's always the case that there is a level of predictability that would be in line with the Charter of Fundamental Rights and the European Convention. I would characterize it as, on one end of the spectrum, we have the Google Spain case. The European Court ruled that certain name searches could be delinked from particular web pages where this was unfair to the individual. At the other end of this long continuum, we have the recent demands from the UK and the Council, saying that intermediaries should be carrying out surveillance and policing of online content with no particularly obvious legal framework under which to operate. And in the middle, we have the rather nuanced and complex Telekabel case, where the European Court ruled that an internet access provider can have a non-specific obligation placed on them to take reasonable measures to prevent access to a specific online resource. With the intermediary being prevented from implementing the injunction in ways that would restrict fundamental rights, based on safeguards that in the first instance would be the responsibility of the member state. So do we have predictability in all of these cases? How do we ensure that intermediaries don't voluntarily over-implement? How do we ensure that public authorities and governments ensure that there are adequate safeguards to limit the range of options available to the intermediary to prevent negative over-implementation? So to start with, we're going to have Gwendal Legrand from the CNIL, who will be describing specifically how the Article 29 group is acting as that public authority to provide guidance for Google to ensure that all of the interested parties have predictability and their interests protected. We then have James Leaton-Grey from the BBC as a company whose content will be partially delinked under cases involving the Google ruling. Then we have somebody that I like to call Kasia for obvious reasons, from the Polish NGO Panoptykon, who will be describing this broad issue of intermediaries and their role in what used to be a public space, which is now a public space which is privately owned through internet companies who make decisions on our daily interactions. Then we have Anna Buchta, who is from the EDPS, who will give us an introduction to the thinking of the European Court and what we can understand from the different rulings that have come from the European Court. And finally, we have Paul Nemitz, who's the director of the Fundamental Rights Directorate in DG Justice, who is going to give an overview of his analysis of whether the legal framework is currently adequate based on the analysis that's provided, and what the legislator might need to do in order to tighten this up. With this, in this regard, I have to draw attention to the Latvian presidency paper on the the telecom single market regulation, which raised questions this week over the legality of the proposal from the European Commission, that it is reasonable for internet companies to filter and block traffic if they believe that they are impeding or preventing serious crime. On that challenging note, I will pass on to Gwendal.
Thank you, Joe. Hello, everybody. First, let me make a short point in my introduction before I dive deeper into the matter and describing what the Article 29 has done in its guidelines to ensure this predictability and harmonized implementation of the Google ruling. In the Google case, which by the way applies to all search engines and not just to Google, it's important to understand that Google is not an intermediary. Google is just a normal data controller. This was made very clear in the ruling. It's the reason why the system works in the following way. If you want some content to be delisted from the search engine, you go to the search engine like you would do with any data controller in the world under European law. You request this delisting, which is a right to oppose. And if the search engine does not respond or does not respond in a way that satisfies you, you can go to the court or you can go to the DPA. So it's nothing new. It's something that all data controllers have to implement. It's not a new obligation that has been put on a private stakeholder following the decision of the Court of Justice. And I think this is very important to understand, that they have made it very clear that the search engine is a data controller. Now, following this court ruling, which explained that in some cases you need to delist the content, and in other cases the content still needs to be there and not be removed from the index of the search engine, the authorities of the Article 29 Working Party have been working, and we published some guidelines at the end of November. The objective was, of course, to ensure this predictability and harmonized implementation of the ruling, to provide the data subjects and companies with a common interpretation and common criteria that DPAs would use when they receive the request that would be sent to them following a refusal by a search engine. What have we said in those guidelines? Well, mainly 4 points that are very important. First, we clarified what delisting means. Delisting does not mean removing content from the search engine. It's only removing the result of a link to a URL on the basis of a person's name. So the content is still out there on the internet. It's just when you type a query on the basis of a person's name that the content does not appear. If you make a search on the basis of other content of the publication, it will still pop up and you will still see the result in the search engine. So this, you have to understand this because it's not removing in a very absolute way content from the search engine. Second point is who can benefit from this right? This has also been clarified in the guidance. We're talking about a fundamental right, so it applies to everyone. And we assume there should be a link with the EU territory, for instance, being a citizen or resident, which means that probably a Chinese in Hong Kong with no link with the EU would not benefit from this right. Third point is the effect of delisting. The court said very clearly that the delisting had to be effective. It means that the decision should not be easily circumvented. If you look into the legal arguments, they're talking about a data processing operation, which is Google Search, which is operated by Google Inc., which is accessible by Google.com. In some countries, there's national versions of the search engine of the data processing, for instance, Google.es in the Google Spanish case. And so we're talking about one single processing operation at the end. So it means that, and this is what's said in the guidelines, that all the extensions are concerned, including, of course, the .com, and this has been widely discussed already, including in this conference. The fourth point that was made in the guidance, in the guidelines by the Article 29 Working Party was the relation with the publishers. So we said there's no legal basis for routine transfer from the search engine to the publisher when some content is being removed. We also say that some statistics should be made widely available concerning the positive and the negative requests, the requests that have been accepted and the requests that have been refused, so that everyone can check if there's a correct implementation of the ruling. The last point, which is in the guidelines, is the list of criteria that is going to be used by DPAs when they receive requests following a refusal by the search engine. And we explain there's a list of 13 criteria. None of them is an exclusive criteria that would mean that there was necessarily be a decision either to keep the content or to remove the content, but it's a list of criteria that are being assessed by the DPAs when they receive the request to ensure the predictability, to make sure we all check the same criteria in the same way. And we sent letters to the search engines to present those criteria to make sure that they had officially received the criteria, and we suggested that they might use those criteria in their own assessment when processing the requests that are made by data subjects. So this is more or less the points I wanted to make. In this specific Google case, there has been a lot of coordination work by the DPAs to make sure we had some consistent guidance by the DPAs to explain how we would implement the ruling, and these criteria were also addressed to the search engines to help them in implementing the ruling. So hopefully we treat the cases in a very consistent way. And in any case, the court has organized the discussion between search engines and DPAs, because when the search engine makes a wrong decision according to the data subject can appeal to the DPA, which will check if the decision by the search engine was the right one. And once again, keep in mind, this is nothing new. This is what all data controllers do under European law. When you're a data controller, you need to allow people to exercise your rights, including the right to oppose. And here, we're just talking about a specific implementation of the right to oppose. Thank you.
Thanks, Gwendal. I overlooked rule number 1 of policy discussions in relation to data protection in Brussels, which is, if you're going to be imprecise, do not be imprecise when you're sitting next to Paul Nemitz. So what I meant to say with regard to the interests of the BBC in this particular issue was that they are an organization that are impacted to an extent by the ruling, and not that they have to de-index or de-link anything themselves. So with that clarification, and hoping to be more careful for the rest of the panel, passing on to James. Thank you.
Thank you. Yes, in a moment I'm just going to come back to a couple of things that Gwendal said. But I think I'll just make a couple of general remarks, if I might, first on the two cases. I think there is a similarity. When you read the two judgments, at first sight there seems to be two very, very different outcomes. But I would suggest that actually there is something, and it's something which goes to the heart of this panel, which is that the court has effectively outsourced the balance to be made between different fundamental rights to third parties. Now, whether they're intermediaries, whether they're different companies, in this instance, or in the two instances, Google is now being asked to make balancing judgments between fundamental rights that the court itself didn't actually tackle. When you look at the Google Spain case, it didn't actually tackle the issue of whether the freedom of expression of La Valencia, the newspaper involved in the case, was or was not in balance or out of balance to the individual involved, the data subject. It effectively said it's perfectly legal to publish it, but we're now going to remove the link. which in effect saying it's legal, but we can't really like this, so we've got a disconnect between the two fundamental rights. And I think that's true in the Telekabel case as well. So there are similarities in the case. Now, actually, I have a great deal of sympathy because, with this situation, because actually these are very difficult balances. We tend to put the fundamental rights, we write a piece of law around a fundamental right. And actually trying to write a piece of law that says, and now we're going to balance all of these, is incredibly difficult. I have some sympathy. But in the end, that's society's problem. Surely we shouldn't be outsourcing that to private companies to try and do it for us. I was on a panel with Jan-Philipp Albrecht, the rapporteur, who, from the Parliament's perspective, has been taking the lead on the new regulation. And in the panel, he said, I don't think data protection legislation is the right place to conduct a balance between freedom of expression and data protection. Now, on one level, I think he's absolutely right. The problem is, because there has to be an exception for freedom of expression in the regulation, that is where the balance will occur, because it will occur in terms of legislation, in terms of litigation around that exemption. So I think we've got to get used to the idea that actually we as society have got to start looking at some of these slightly thorny issues. So I'm nervous of this outsourcing. I'm also nervous because actually I think our present understanding, and indeed, dare I say it, even the new regulation, is slightly behind the curve, to use that American term. It's actually already losing track and traction with the technology. At the moment, we understand search to be something that is done by an algorithm. You sit in front of a computer, you type it in. Search can already be talking, not typing, but talking to an internet IPTV, an internet-connected television, and say, get me the news. And they have algorithms, they have news aggregators that go out and get a variety of news sources and then provide them to you. La Valentia, BBC, Deutsche Welle, all of these could be in there. But you, as the consumer, wouldn't know if there was something missing from that because the search engine has removed a link. Search is no longer just going to be about computers. It's going to be in many, many aspects of our lives. And I think we also, as a society, have to recognize and tackle that. I think overall, I'm nervous about the mechanisms. And here I will come on to Gwendal's points, because it overlapped where I was going anyway. I don't think any data protection authority, and I have, as I say, I have a great deal of sympathy for the Article 29 Working Party in this situation. They had to write something. But I'm afraid, I think we go back to the idea that there are only two kinds of beast in the world. There are data controllers and data processors. Google, a data controller? Really? When you start looking at all the other things that a data controller has to do, are we really saying Google has to minimize all of the data that it has about us as an individual data subject? How are we going to impose that? How are we going to impose all of the other rights and obligations on a data controller onto Google? It doesn't make sense. That isn't the DPA's fault. That's the fault of actually trying to use these classifications that were from the age in which IBM only produced about 40 computers a year. We actually need to understand that technology has moved on a bit. And my nervousness about the system. No automatic contact to the publisher. We may not know that the link has gone. And the data subject can appeal to the Data Protection Authority, but the publisher cannot. How on earth is that fair? This is a closed court where only the defense can provide witnesses. This is not a balance. And neither should it be the Data Protection Authority's role to balance between fundamental rights. They are there to protect one, which is the individual data subject's privacy rights. That is right and proper, but we need another mechanism that understands there are other fundamental rights at issue here. So I think there's a sort of nervousness that the lack of automatic contact to the publisher may know things about this individual that Google cannot, or any other data subject, any other search engine cannot know. And when we come to the Telekabel case, the instruction to balance the rights between the rights of Telekabel's users and the copyright owners, I think is an almost impossible one. And I don't think it's fair, and I think we need to be tackling these things, not individual outsourced intermediaries. Thank you.
Thank you very much, James. And we'll just pass straight on to Kasia.
Thank you. Katarzyna Szymielewicz, if anybody wanted to know how it sounds. Before I move to what I really want to say, just a quick note on what James just said. Actually, I really like this idea of Google being the data controller according to EU law and being forced to obey all the principles, including data minimization. That's the only bright side of the judgment that I see, maybe. I'm sure that Gwendal will say more about the delinking, how it's going to work, because it's not really about delinking the content. It's far more complicated, maybe more nuanced, but this is not my point. I will not go into that. What I want to do, I want to move back to the problem that was already advertised by the title of this panel, Let's Fix the Interwebs, because we really have to see where we are with all this discussion. So the situation where we are, where we have placed ourselves with years of our own consumer choices, is the situation where there is private infrastructure for the society in all respects. So whatever we do, whether this is a communication between individuals, the private one, or whether this is access to information, access to media, access to some public services, certainly free expression, it goes through private infrastructure. And effectively, we individuals and the states have no control over this data. I'm not advertising the opposite model where the state would be the provider, don't get me wrong. But it really is a new situation where there is private company between us in all these extremely sensitive activities. We have to acknowledge that situation because it produces every day a number of problems that cannot be ignored. And from our perspective, an NGO working on privacy, but not only on all the digital rights in Poland, we get a lot of letters from people who are angry or desperate in both situations. Some of them complain that content that is infringing their privacy remains online, be it Google, Facebook, any other company out there, but of course the biggest one have the biggest, so to say, outreach. And we have no response to this because most of them are not regulated by the EU law, or the courts say they are, but it's still debatable. On the other hand, we have people who say, wait, I have my account, and Facebook comes and says, you are not real. Prove that you are real. Send me your data. Send me your ID. Send me your bill for your energy bill, things like that, because the company thinks, I don't know whether that account is real. On the other hand, we have many fake accounts of public figures being out there for defamation purposes or any other breach of law, and they also stay on the web for far longer than they should. We had a recent case of a former Constitutional Tribunal judge, Ewa Łętowska, famous Polish lawyer who had that kind of account on Facebook, and it took her 3 weeks to bring it down just because she had a phone number of the Facebook spokesman in Poland, and she could get it more effectively, but other people wait months. So these problems are real, the real dilemma I see is whether we acknowledge the extreme powers that these companies have, the actual powers, and we just ask them nicely, please use these powers within some legal framework, so please observe some safeguards and some guidelines, but use these powers, act quickly, or do we want to say, please ignore your powers, the real ones you have, and let's wait for independent bodies like courts, prosecutors, police to react. I think both are wrong. We are between the rock and the hard place here. None of these solutions is a good one. In the first, of course, we empower them even more, and we acknowledge that they are the judges of the digital world. In the second one, we make people wait months for decisions, and we make people forced to use extremely complicated international legal procedures, which most of lawyers would I guess, struggle with, not mentioning the users. So it is a hard dilemma, and I believe that both judgments are, in some way, it's the court, the European court, trying to find some responses. In the Telekabel case, the court, in my humble opinion, didn't find the right one because it really said, just do something with the manifestly illegal content, help us fight all the things we want to fight online, but it didn't mention any safeguards. So we are left in the dark with the companies deciding really what is manifestly illegal, and we have no safeguards, at least not in the judgment, that could help us, apart from procedural safeguards, which I believe that Anna will probably talk more about. In a Google Spain case, I do agree with Gwendal that it is based on the law. The court didn't create new obligation, it just clarified existing obligation with regard to search engines. So the procedures, the legal grounds are there. It's not arbitrary in essence, because the right to object to data processing is not something created by the court, it exists, and I really like the idea that Google should observe that, or any other search engine should observe there. But the problem we have, of course, is that in that particular context, there we talk about the public interest exemption from data protection related rights of the data subject. And that's the tricky situation. Here I would agree with James, that indeed we have arbitrary decision being left to the private company, which is not perfect. So what would be my recommendation here? Of course, I would love to have a regulator dealing with all that dilemmas and making the data protection law, the notice and takedown law, the e-privacy directive, whatever we take, far more precise. But we don't have it yet. So, but if I may, saying so many regulators in the room, I would say that some of the safeguards we should consider is definitely the right to response in the context of disputes over content, even if that's data protection related. Of course, I see the difference between the two regimes, but still there should be notification of the source, of the publisher, that the content has been delinked. I mean, not the content, but, well, Gwendal will say more about it, but the search query has been modified, the search result has been modified. We are not talking about delinking the content as such, but there is modification, of course. So that modification should be notified to the source so that the source can actually say, no, I stand up in defense of my public interest. And in that situation, I would recommend that we have a very similar concept as in notice and takedown procedure, where that dispute goes one level up. It's not resolved by the private company. When there is a dispute, that should be resolved by DPA or by independent court. I know it will cause delays, but I would say that this is the lesser evil, so to say, in the situation where we are. Another is the full transparency of the criteria applied. If the company applies any criteria of modification, this criteria should be clear. It's not the case now, and that's a lot to go. When we talk about manifestly illegal stuff, of course, here the disputes might not happen so often, and we might want to see companies actually acting on their own initiative, but not arbitrarily. Again, I can agree with this logic that companies should not wait until police comes when they see something, but the criteria of reaction should be extremely clear. And also, there should be always notification to both the source, because the source, the author, might still defend the content, and to the police and prosecutors that we have such a content. Otherwise, we have the company removing whatever, and the crime continuing. That's a situation that we don't want to accept in democratic society. So I guess that's enough for the starting of the discussion.
Thank you very much, Kasia. I think that the link onto Anna's intervention is clear, so off you go.
Thank you. Not just because we are both Polish, I guess. Good morning. My name is easier indeed. Thank you, first of all, for having me here and giving me the opportunity to make a few comments as part of this very interesting discussion already. Let me maybe take a step back and say a few words about the broader legal framework within which we operate, within which also the court takes its decisions. Since I hear Joe in his introduction make reference to no particularly obvious legal framework which would exist for ISPs within which to operate, we speak about non-specific filtering and other obligations. That suggests a certain vagueness, uncertainty, if not a legal vacuum. So I think it would help a bit to understand maybe where the court is coming from in all these discussions. First of all, obviously, balancing is nothing new in European or any other legal system. This is in essence what the law, or politics for that matter, largely are about. It's about resolving apparent or real conflicts between competing interests. Balancing of fundamental rights obviously is not new in the European legal system either. Long tradition of the European Court of Human Rights, who used to do precisely that for many years, and with a lot of emphasis also on balancing of the right to privacy and freedom of expression. It is obviously also a key function of the jurisprudence of constitutional courts at national level. Balancing by the Court of Justice of the EU was a part of its case law long before the Charter became so prominent and legally binding following the entry into force of the Lisbon Treaty. Before that, we had the general principles of EU law, which were guiding the interpretation by the Court of EU legislation. Obviously now, once the Charter has the legal status equal to the treaty, so it has become much more prominent also in the jurisprudence of the court. We have seen it, I think, most notably in the annulment of the Data Retention Directive, the Digital Rights Ireland and Zeidlinger case, where, to my knowledge, it was the first time ever that the court annulled an entire directive solely on the basis of its incompatibility with the Charter of Fundamental Rights. Before that, it happened once also in the Test Achat case, where a specific provision was annulled because of its incompatibility with the Charter. But here we had, for the first time, the court cancelling an entire directive, not for procedural reasons, wrong legal basis, etc., but because of its incompatibility with the Charter. On top of that, the court did not provide for any transitional period, did not maintain the effects of the directive like it used to do in many other cases. So that shows that the fundamental rights principles are really taken very seriously. And obviously also, fundamental rights hardly ever have an absolute character, hence the need for balancing. In the Charter, it is very clear when you look at Article 52.1 that there may be limitations. Precisely, this is what the Charter already provides for. And there are certain conditions. So those limitations on fundamental rights need to be provided for by law, necessary and proportionate, and also serve a genuine objective recognized by union law, or serve the purpose of protecting the rights of others. Before I make a few comments on some of the remarks already made by the previous speakers, I would like to briefly consider what would be the alternatives for the court, including the Court of Justice, to this balancing act. Can they adopt some other technique when issues of conflicts between different interests, different values are at stake? And indeed, this balancing act in legal theory is often considered as intrusive. So the court may prefer to take a different type of decision whenever possible. So one of such alternative techniques would be the technique of categorization. In other words, the court draws a line and then decides that a given situation falls on one side of the line or the other. For instance, deciding that a specific case does not fall within the scope of EU rules in this case at all, in which case, of course, it's resolved, even though perhaps not necessarily a clear answer is given. This happens sometimes in the free movement cases. But not often. Usually the Court of Justice in the EU prefers to take a functional approach and at least provide some substantive answer. Another technique would be so-called exclusionary reasons. So the court simply assumes that a certain situation, certain legislation, behavior, from the intent of a measure, it's clear that it could never be justified under specific circumstances, and this is enough to invalidate it. But that usually happens, again, in the free movement cases where purely economic aims can never justify restrictions because they would amount to protectionism. And finally, there is another alternative which is the procedural test. So the court verifies whether the member state observed certain procedural guarantees, were putting in place restrictions on a particular fundamental right. And this usually happens in areas where the member states retain at least, well, a big part of the competence, health, culture, but also perhaps in the future freedom of expression. This brings me to the one of the cases mentioned earlier here, so the Telekabel Wien case, where I think the court kind of comes close to this procedural test, where it specifically states in its judgment that in addition, or the injunction notwithstanding, it must be possible for national courts to check that appropriate checks and balances have been put into place. Now, of course, I understand that how that could work out in practice, it's another discussion, and I won't go into that in details right now. But just one final remark. I would respectfully disagree with Kasia that, especially after this case, we have no safeguards. We don't really know what the guarantees would be, especially in the field of, let's say, reconciling data protection and privacy with the needs for IPR enforcement. I'm pretty sure this is not how the court sees it. Indeed, already in its judgment in Pro Musica, which was, well, years ago, the court considered the overall framework of balancing between those two needs and decided that it is indeed up to the member states to strike a fair balance between competing different fundamental rights protected by the community legal order. And I would submit that it is indeed within this overall framework of balancing by the member states based on the Charter and the implementing rules of EU law that the court is taking its further decisions on the balancing of those acts. I could say also a few words about the Google Spain, but I don't think that the world will become a better place if another lawyer comments on that. So thank you very much.
It's so unusual for an activity of a lawyer not to lead the world to become a better place. I can't resist making a comment on the data retention case, because there was a previous data retention case where a more general question was asked in Bonnier Audio, which was, in appropriate circumstances with the right safeguards, would it be appropriate for retained data to be used for IPR enforcement? And the court came to a ruling that wasn't a million miles away from the Telekabel case, which is in inappropriate circumstances where the member state implements a specific law and it's necessary and proportionate, then this would be allowed. When the court was then asked, well, is it proportionate to retain this data? The court said, well, no, which I think is interesting when you look at the predictability that we may or may not have after the Telekabel case. I've been extremely mean to all of our panelists by placing Paul last, because Paul is not somebody you want to be speaking before if you're not agreeing with them completely. So grab your popcorn. It's Paul.
Yes, thank you, Joe. I think, first of all, just to say something on the last intervention, maybe we are all learning what data retention means in a world in which the digital progresses, in which the computers become more powerful, the algorithms make it more easy to understand you as a human being for metadata. And maybe this learning process takes place not only among people like us here, but also among judges. And in that sense, I wouldn't call this lack of predictability. I would say the judiciary also learns, and our Court of Justice certainly, with two judgments in very close succession, namely the data retention judgment and the Google judgment, has shown, I think, that it really has worked itself into this great challenge of our times and has probably on a global scale taken the lead in the judicial structuring of the digital space. Now, I will not dwell on data protection issues. I think this is a very important discussion also in relation to the other issues you mentioned in your introduction, and also to the for the general doctrine on how fundamental rights in the digital age can be realized and applied. And I also say this very clearly. I think now that one of the speakers is missing, it's maybe a little bit an unfair panel, because we have here sort of 4 friends of data protection, and then we have the colleague from the BBC, and I recognize. I just wanted to say this. I think it's it would maybe have been more balanced with one more colleague, but still, even then, it is one could have balanced it a little bit more. And I say this because I now have to come back on some things I've heard from the colleague of the BBC, and I was a little bit astonished about what I heard. I don't know whether this was now a journalistic contribution or whether it was a contribution from the public institution BBC. And maybe you can clarify this afterwards, because first of all, it's of course wrong to say that the court did not address the balance between privacy and freedom of speech. In all the judgments we are discussing, the court addresses these balances. And I just would like to quote, for the information of the colleague of the BBC, this place where the court addresses it. It addresses it twice. It says first in paragraph 85 that Google is not a journalistic institution, and that one has to make a difference when looking at the situation between Google as an operator which aggregates data and which is subject to privacy law, and journalistic institutions. And the court expressly says here that it may well be that the individual in certain cases has an action against the data controller, but not against the publisher of the web page. That's important because Joe, he already corrected it, in the beginning gave the impression that the BBC would be obliged under the Google judgment, under the same criteria, to take things down from its website. That's wrong. What is also wrong is that in relation to Google itself, the court does not address the balancing. That's what we've heard from, hopefully, the journalist of the BBC and not the official institution from the BBC. But even if it would have been a journalist, I mean, there's a lot of easy bashing on Europe, including the Court of Justice, in the UK press, and that's why I enjoy coming back on this. We get great contributions on EU law, on the other hand, from British colleagues also at this conference, and also, the big teaching books, Craig and Buchta. And maybe it would be good if the BBC and other press organs in the UK, before bashing on the European Court of Justice and on Europe generally, would first go back to their own superb legal scholars on EU law. So let's have a look at the statement that the court does not address the balance as far as Google is concerned. Also wrong. Paragraph 81. Explicitly, the court says that the controller must address the balance. This is about Google. And that balance may depend in specific cases on the nature of the information in question and its sensitivity for the data subject's private life, and on the interest of the public in having that information, an interest which may vary, in particular, according to the role played by the data subject in public life. The data subject being the individual about which the link is. Now, if a lawyer reads this, the most important words are actually in particular, between the commas. Why? Because this in particular means that the court here only in an exemplary fashion mentions one criteria, but there are others. And these other criteria are in many other judgments. So it is fundamentally wrong, in particular for a press institution, who should know that there is ample jurisprudence starting at the European Court of Human Rights right down to national normal courts on the balance between private interest and public interest, to give the impression that, yeah, again, Europe, they don't understand the freedom of speech. I think it's outrageous that the BBC says things like that. So, what is the jurisprudence the court refers here to? I would just like to mention the most important leading cases of the European Court of Justice, of the European Court of Human Rights, which give detailed criteria on the balancing between private protection of private life, personal data on the one hand, and public interest. The von Hannover case versus Germany, C40660 of 08, and the Axel Springer case, 3995408. And, if you want to have the paragraphs in the von Hannover case, 1008 to 1013, Axel Springer, 89 to 95. And the beauty, for the small talk at the beer table among journalists, bashing on Europe, the beauty of these cases is that, for example, if the Washington Post writes an article saying there is this case of the pianist who now asks for the critic of his concerts to be taken down under the right to be forgotten. And here we see what all this jurisprudence of the European Court of Justice leads to, blah, blah, blah. Then you go back to the jurisprudence of the European Court of Human Rights, and in the von Hannover case, you find the very clear statement that journalistic work on critique of artistic performances obviously are of such a status of public interest that this public interest of having them in the public will always remain. So what I'm saying here is, please, journalists who talk about it or report about this, before, cheap, easy bashing on a court which deserves the same respect as any national constitutional court, or for that matter, the Supreme Court of the United States, please read all the underlying jurisprudence, previous jurisprudence, to which the European Court of Justice implicitly in this paragraph refers. Right, sorry, I didn't want to talk about privacy. I did maybe a little bit too long. Now I would like to just say the other issues. We have 3 issues here: copyright, data protection, privacy, and the issue of crime. And in all these questions, the issue is what duties do platforms, internet service providers, search engines have? And the first question we have to ask ourselves is, what is our aim? What is the aim of the BBC representative if he says, well, Google shouldn't be even looked at as a controller? What is the aim of EDRi when they start this debate here? This question has to be raised. Because when I hear from the BBC they are nervous about the free speech implications, well, there are also many people who are nervous about a world in which internet platforms, powerful search companies like Google, are not subject to any binding law of Europe anymore. Because let's not forget, that was the aim of the Google case in the first place. Google pleaded in this case that its activities are absolutely not subject to any law in Europe, because the answer to the search question comes from California. And if Europeans have a problem with these answers, please turn to the judge in California and please accept that Californian law is applied. So what is actually the purpose of this debate? What is your aim? What world in the digital do you want to live in? And there we have indeed different constellations. We have constellations here where we talk about whether the law is sufficiently precise, and it has to be precise when it is about ingerence in fundamental rights. That's a legitimate debate. And we have another debate, which is hotter, whether self-regulation or voluntary activity, quote, quote, is it really voluntary, can be the subject of ingerence into fundamental rights. So we have to make the difference between these two debates. And we have to look at each of these areas in a copyright, data protection and the issue of crime, first of all on their own merits, before then we go to a higher level of abstraction and look at the commonalities. And not always these commonalities are justified. You know, just to give you a fact, copyright takedown by Google, 345 million cases according to the press in 2014. Data protection requests, right to be forgotten, in the 100,000s. So, you know, we're talking about different worlds. I mean, copyright takedown is driven by money machines. And Google has a clear commercial interest to comply because some of the people who ask for copyright takedown are advertisers. In the privacy area, it's a completely different game in terms of the interests behind it. Last remark. On the Telekabel case, I would like to point out that, in contrast to what I've heard on this panel, again, it's not right to say that the court has not seen the three positions of fundamental rights which have to be balanced. Namely, the position of the company, right to do business, which the company which is asked to make access to certain copyrighted content impossible. Second, the company which has produced the copyrighted content. Third, the interest of the user. Please read paragraph 47, where the court spells out these three fundamental rights position and says, the law, it's not about the company, the law has to balance these three positions. And in order to balance these three positions, the court then also says very clearly in paragraph 57, there must be an appeal possibility also for the user, for the internet user, if copyrighted material is not accessible anymore. So what we have in the Telekabel case, I would say, at least from the issue of the access of justice, is a perfect symmetry. The copyright owner can go to court, the company providing the intermediate service can go to court, and the public person who would like to get to the material but cannot anymore can go to court. Very clear. And here now at the end, I have to admit that we do not have this symmetry in the constellation of data protection. And the question is, and I would like to refer that question back to the BBC. Is it right to ask for that symmetry? And let me ask the BBC. I certainly have recourse against the BBC if the BBC reports certain things about me which are not correct, slander and so on. I can go to the court. But can I go to the court against the BBC if the BBC says, well, sorry, Paul, what you said today is so boring, I'm not going to report about you? Because that is the opposite position. So do I have recourse in traditional situations of press law if people do not create internet content, internet links about me? And if the answer to that question is yes, then let's continue to discuss whether there should be legal recourse symmetry also relating to Google.
Told you that would be fun. I need to briefly, before I pass on to James, who's shifting in his seat, what is the intention of EDRi was one of the questions. The intention of EDRi was to jump into the moderator's spot after the moderator and organizer couldn't make it. I think I trust Google less than Paul. Google is implementing, on the basis of its terms of service, US law in Europe and around the world. It's de-indexing millions of websites day by day. It's implementing DMCA notice and takedown procedures on the basis of US law with European citizens. Do I trust Google not to over-implement the ruling, irrespective of the European law that it has shown itself to be somewhat disrespectful of, and protect itself with its terms of service? I do fear that this is a possibility. There must be an appeals process, Paul says, in the Telekabel case. Well, the European Commission has run several legally questionable self-regulation projects with internet intermediaries, where they've always advised the internet providers to have terms of service which say, ban everything that's illegal, and that way you're safe. If there's a question, you don't have to worry about it. Then you're not appealing the legal decision, you're appealing terms of service which are generally open-ended and allow the intermediary to do whatever they want, and it's safe for them because they're intermediaries. It's not simply, the intermediaries don't rely on the law, they rely frequently on the terms of service, but I'm open to contradiction. I'll pass on quickly because it would be good to have a few questions. James, I'm sure you're ready to answer.
Yes, right. A couple of thoughts. Firstly, the characterization, I actually, as the BBC's data protection officer, I am also quite strongly in favor of personal data protection rights and spend a lot of my time trying to ensure that they are upheld. I think the characterization, and let me be absolutely clear, I am speaking as an individual, as somebody who has worked in this sphere for 12 years in privacy, and before that for 8 years in parliamentary reporting. I have to say, I think Paul's was slightly closer to my parliamentary reporting days in that I appeared to hear him say, so the European Commission believes that the BBC is bashing Europe and isn't impartial. Because we were in the same group as the tabloids in the UK. I suspect that's not what Paul implies, I'm sure. Because I would assure him that I have spent a great deal of time talking to politicians of both left and right in the UK, both of whom thought we were either too partial or too against Europe, and have spent a great deal of time making sure that we remain absolutely impartial and provide facts. And actually, perhaps I should emphasize that, facts. I didn't actually say that the two judgments didn't mention balance. They mention balance. My assertion is that they don't achieve it or don't try and actually make the balance. They talk about it, but I don't think they achieve it. And I think that's where we come back to. We're back into this. For me, the fundamental is the lack of transparency in this system. We need to be able to see, the publishers need to be able to see what's going on. The public need to be able to see what's going on, that there's a transparent mechanism that is actually trusted by both sides. And I don't think that's in this system. But in the end, what's this about? This is about balancing fundamental rights, not just talking about it. And I don't think the right of the individual to find that La Valencia article was considered in that court judgment. What was considered was, yes, the freedom of expression, the right for the judgment, for the original article to exist, but if you can't find something, if you have no filing system, then actually it might as well not exist. And that is why I say the balance wasn't achieved. But I hope we'll now get into this debate.
Kasia, briefly. And does anybody want to, we've got Kasia and, okay, we'll just take the panelists' very brief comments and then audience.
Yes, just brief comment on the existing safeguards and the existing jurisprudence that helps us strike the right balance. I strongly agree with Paul and Anya saying that they are in the jurisprudence and they are in the law. But the problem that I see, and I just want to repeat it because I think it's quite significant difference, is that these guidelines or safeguards will have to be applied by private companies. And that's a new situation. So we can maybe imagine a parallel with having a district court in the whatever far corner of a country with very low, hopefully never it will exist, but we might imagine having a court that takes very bad decisions because of lack of education, lack of lack of time, maybe it's overburdened with cases. You know, things might happen. And in the legal system, in the public system, we always have the right to appeal, and we have some procedural safeguards, like all the paperwork that goes through the court, all the rights to respond, all the post office delivery and stuff like that. So at least we want to think in this private court situation that we have at least this due process somehow safeguarded, and we have the right to appeal, and we have the right to respond, just in case the court turns out to be a bad court in our case, even though all the law is there, all the safeguards are there, and all the nice principles are in the law. Thank you.
Yeah, I have to be very brief, just to mention a section in the court ruling in Google that was not discussed, but we're only talking about delisting on the basis of a person's name. The rest of the links to the web page are still there. That's a very important thing. The other thing is that we have two different controllers there. You have the website that is publishing the content, and you have the search engine. The person is exercising his rights with respect to the data controller, which is the search engine. And the court is very clear about this, because there's a paragraph that says that the operator of the search engine, this is a quote, is obliged to remove from the list of results displayed following a search made on the basis of the person's name links to web pages published by third parties and containing information related to that person, also in a case where that name or information is not erased beforehand or simultaneously from those web pages. So we're talking about two different things, and I think it's unfair, it's wrong to link removal on a website, a BBC website, or any other website that is publishing content, and the act of requesting delisting on the search engine. It's because the search engine provides very better access to the information that the person can exercise his rights with respect to the search engine.
We have three questions. Joris, one person here, and
I think you should use the mic.
oh, sorry.
Thank you. Artemi Rayo, former director of the Spanish agency. Two questions, Gwendal, Paul, and James. First one about, I think the recommendations of the Article 29 are useful, but I think is not the moment for argue that, but there is a kind of a strategy to reduce the impact of the judgment. I would support with many arguments, but there is one of very clear, the name of the thing. The Article 29 is starting to use just the word delisting. Why? I think it's not, I never thought that the words are neutral, and in this case I think words are not neutral. I don't know why everybody is so afraid about the name of the thing, the right to be forgotten. Even the European Parliament erasing in the regulation the thing. I hope all the Commission will be able to recuperate after the judgment. I have a second question about the debate against freedom of speech and data protection. I think this started to be a debate not separated. Why I said that? I don't know if you know, in 1 second, in El País, the main newspaper in Spain, in May 2014, adopted a style book accepting the right to be forgotten, accepting the listing from the search engines news, not erasing news from the archives, but after some time, 15 years, and accepting notice from updating news, they have accepted the right to be forgotten as a right to be delisted. These are two comments and questions, I think.
We'll take the other two questions, and then we'll unfortunately have to wrap up.
Yeah, so I'll try to be very constructive. I think Paul's words were very provocative. I think the problem, though, is if you look at this from a freedom of expression perspective, both the European Commission and the Court of Justice of the European Union are working on very fragile territory. And this is because they have not established like a tradition of dealing with freedom of expression within EU law. And I think this is one of the main reasons why it's very worrying that if it really comes to the point that there's clearly this interest at stake, that the references remain implicit. And as the gentleman from the BBC says, there is not an effort by the court to really tackle and to provide more guidance in the way in which freedom of expression has to be understood in this very specific context. So my question would be, like, shouldn't we be worried about that? And why did the European Commission not do much more work over the last decades to really understand how freedom of expression could be balanced in the data protection context? Why weren't there any studies, and why is the Commission keeps on referring to implicit references and doing myth busting and not doing the kind of more thorough work that needs to be done to make sure that freedom of expression is respected?
I think the question is very clear. There's a third question here, and if he promises to be brief, there's a fourth question in the middle.
Thank you, Joe. Brendan Van Alseno, University of Leuven. I wanted to pick up, well, I mean, it's been implicit in a lot of the statements, but mainly what Gwendal was saying at the end. Search engines control their own index. I don't think there can be any question about that. It's kind of silly to argue otherwise. But thinking longer term and beyond just Google Spain. So Google controls its own index, but does Facebook control what we post? So, and I'm not talking about the case where it's somebody asking for information to be removed that they posted themselves and they want to be forgotten. I'm talking about user-generated content about me, right? And I mean, clearly Facebook is not a neutral host. They have timelines, they have news feeds, they have et cetera, et cetera. Are we going to differentiate? Should we differentiate? So my basic question is Facebook next? Second quick question, sensitive data. I agree. The European framework under 7F allows flexibility for balancing. I agree with the court on that. I agree with what's said on that. But the guidance in terms of information relating to criminal convictions also coming forward from the Article 20 Working Party, how do we deal with information about criminal convictions relating to a public person? Is that covered? Okay. Does Article 8.5 allow that flexibility? Thank you.
It's clear. I think we need another panel next year for those questions there. Very quickly, and then final comments.
Willem de Beugelaar, Belgian Data Protection Authority. When Google have to execute the judgment, will it only be for Google Spain or the Google searches in Europe, or is it worldwide?
Okay, that's a straightforward and unusually uncomplicated question. Okay, if everyone could wrap up. There's a lot of questions in 5 minutes, please. Thank you very much. I know everyone's very keen to know that EDRi is running a fundraising campaign. You can find the information at donate.edri.org. Thank you.
That's our response.
We'll deal with the final comments will be in the order of the initial questions. So we'll start with Gwendal and work through the list briefly.
About well, who's next? It's clear right now that the guidelines apply to the search engines. It's clear that the decision was Google Spain. However, it applies to all search engines, and I think this is understood by all the search engines. So this is where we stand now today. Now we still have in the directive, and we'll have tomorrow in the regulation, a right to oppose and to answer the question by the president of the Belgian DPA. I mean, the guidelines by the Article 29 Working Party make it clear that all the relevant domains have to be covered. So this is very clear. So obviously today, what we see is that Google is only removing the content from the European domain names, which is not in line with the guidelines by the Article 29 Working Party. And I just mentioned a very funny thing, which I see, and I stop after this. You can go to google.com and you will find the form, the removal form. So it's very surprising that you can fill in the form on Google.com, request removal on Google.com, and it's actually only effective on the European domains.
Yeah, I will leave the key question to European Commission, but just on the Facebooks and any other intermediaries' interventions in the content, my opinion is, of course, if they moderate or edit or whatever, they take different responsibility than for hosting. I mean, that's not hosting, that's editing, that's becoming fully liable for the decisions you make. And here I think there is no debate in the law. We should probably clarify it better in the new privacy directive, I mean, when it's revised, but I don't think that's debatable.
I'm sort of rolling up questions 2 and 3. I think We have to remember search is broader than Google. Really one of the things, and actually I think there's nowhere near as much of a difference across this panel as would at first appear. The reality is that what I'm saying is that the balance has to be in practice, not just in law. That actually we need to have mechanisms, we need to have transparency, that the balance for the individual and society's right to know about things and the individual's right to have that link suppressed has to be balanced in a practical way, and that has to have transparency, because these are important fundamental rights, but they are all fundamental rights, and we need a better mechanism. And the balance has to be in practice, and we have to accept that the technology, the Facebook's already moved on. We are going to be in a constantly changing position, and actually just waiting for however good a CJEU judgment on an individual case is not going to give us the practical balances that we need to be able to make this internet work.
Very briefly, I would totally agree that ultimately what the court does is answering questions from national jurisdictions, and those questions may be of different quality, more or less intelligent, depending on the case. So certainly the court is not setting public policy or legislative policy for the EU. Let's not forget that it interprets the law. So there certainly is a role for the EU legislator and for the Commission as initiator of possible legislation to take the responsibilities. And just one final remark, since Brendan very helpfully referred to Article 7F of the current directive, just to stress that this is a clear example where balancing of various interests at stake in the context of data protection law has been done by data controllers for many years, or should have been done for many years. So again, this is nothing new, and if you are interested in knowing more about that, there is an excellent opinion of the Working Party 29, published last year, which again will explain how these things can be done in practice without infringing on any other fundamental rights any more than absolutely necessary. Thank you.
I think it would be overcharging the boat to ask the European Court of Justice in one judgment to set out all the mechanisms and solve all the problems of this world. But my thesis is the judgment is very good because it does what we normally accept from the highest courts. It gives the leads to other courts and also to the private parties to move in the right direction. So, of course, the concretization work has to take place by DPA's Article 29 group, that's what they're doing, and if necessary, also by national courts. So, you know, if people say the European Court should have done this or that, you know, my question back is, well, does your national constitutional court do they do that? Let's not be more critical of Europe institutions than we are of national institutions. I think the call on transparency of Google, which I've heard from the BBC, that's, I think, exactly right. Google in Europe has more than 90% market share in search. So the fourth power, you know, the democracies is not only government, legislative and executive, it's also the press and civil society. They are right to demand from Google total transparency and they have to exercise their controlling function. And to reconcile myself with the BBC, I like that very much. Please exercise your controlling function over transparency of Google rather than for saying Google shouldn't be subject to European law as a controller of data protection. Thank you very much.
Thank you, Paul. Of course, if the national constitutional courts don't do that, then the rights of the citizen will not be respected in the implementation of the Telekabel case, which brings us round in a perfect circle. I hope this was as interesting and informative for everybody else as it was for me. The panelists were magnificent, so I'd like to invite you to thank them, and thank you.